risk you run. Like, they can't guarantee, like, class sizes or anything like that. I mean, it's just...
Good afternoon.
I feel like people's expectations are way too...
Council, can you all hear me?
Yes, Your Honor, I can hear you.
All right. And the 509 number, I assume that's Mr. Chesky? 5683?
Yes, Your Honor, I'm present.
Okay. I had a couple of folks in the waiting room. This is a participants-only hearing, so I don't know if is Sarah Hollister somebody you were expecting to be present?
She, Your Honor, is a paralegal in our office. She should be on the YouTube stream.
Okay.
I'll send her a message.
Okay. I just want to make sure we have any participants in here, but I don't see, that's the only one I see who's still in the waiting room. And we've got a message posted to go watch it on YouTube, so.
Right.
All right. We are on the record. Just to get things started here, let me get organized a little bit. I've had a criminal dockets all morning, so I got to get myself back on track here. So we're in cause number 22868-08, Department of Labor and Industries, State of Washington versus Dueling Enterprises, LLC. This is on for a second continued hearing, show cause hearing. Present, I believe I have from the Attorney General's Office, Michael Hall and Brian Dew, and on behalf of Dueling Enterprises, Mr. Chesky. Is that accurate?
Yes, Your Honor.
Yes, Your Honor, Mr. Selsky, yes.
All right. I apologize if I mispronounced your name. It's one of those days. I do have a legal assistant who is, or an administrative assistant who is sitting in case we need to have any additional dates set, so she's monitoring the hearing as well. So I guess what I'd like to start on this hearing is I've received a lot of documents. I've had an opportunity to go through all of them, I believe. Initially when this hearing, or when this case started, there was a question that was raised by the court. And I guess I want to start there because I think it's critical to have that question determined. That has to do with jurisdiction. I had an opportunity to review through the case, and I guess my question, this would be to, I don't know, is Mr. Dew or Mr. Hall going to be handling the hearing today?
I will, Your Honor. Michael Hall.
Okay, so I guess my question is there was no summons ever filed in this case. So my question becomes is how do we get personal jurisdiction or in personam jurisdiction over the LLC?
Well, I guess the first thing I would say is that that argument has not been raised until now. We've done a number of these in different counties across this.
Okay, that's not my question.
We've done a number of these in, yes.
That's not my question. What happened in other counties is irrelevant to this case. The question is, there was no summons filed in this case. My question is, how do I get personal jurisdiction over the LLC?
I believe Rule 65 gives you jurisdiction, the rule regarding temporary restraining orders and preliminary injunctions.
Court rules don't grant jurisdiction. That'd be statutory counsel. And the court rules require a summons to start a civil proceeding. That's my question, and I don't see that any place in here.
Well, we have not filed a summons. You're correct about that. I guess I'll just say it's not my understanding that that's what the court rules require, but I hear what you're saying, Your Honor, and if we need to do that, we will do so.
Well, I guess I'm asking you what would be the basis of not doing And the analysis I did, because when this issue was raised, not necessarily a summons issue, but a jurisdictional service issue was raised at the very first hearing, and that obviously was a question. It was raised by myself when I inquired as to whether we had proper service, at which point I was advised that was not the case. And I did not find anything in the court file since that time, and I reviewed all the declarations of service that would indicate that that had been cured. In the process of that review, I discovered there was no summons, and so that caused a bit of concern. So I went and tried to figure out how the L&I statute might create something that you didn't need that, didn't find that. That's why I'm asking you that question.
Okay, Your Honor, the L&I statute that concerns proceedings such as this, the order of immediate restraint, and the proceeding that we're engaged in right now says that the court has jurisdiction to grant injunctive relief or temporary restraining order pending the outcome of enforcement proceedings pursuant to this chapter. And that's correct. RCW 4917. Pardon?
Correct. I understand that. I don't think there's any question.
That's what established.
Well, the court has jurisdiction over the case upon filing the petition. I would agree with that, but that doesn't give me jurisdiction over the defendant. That just gives me jurisdiction over the case. It's still, you have to serve the defendant before you have any jurisdiction over them.
Well, they have been served with the papers. We did file declarations of service, but they have not been served with the summons. You're correct on that.
Well, they were not served a temporary restraining order.
They were.
No, they weren't.
Sir.
That was the issue that
we filed the
hearing. Based on your declaration of service, they weren't served that order.
2 days ago, we filed a declaration of service demonstrating that they were.
2 days ago? Okay, sir, Michelle Kennedy. That's the one you're talking about?
Right, manager of the restaurant.
Right, this is an LLC.
Your Honor, I do see we received a docket, not a docket notice, a proof of service on the same day. It's document number 41. I don't know if that helps.
That was service of the petition. That was done on, that I've seen that one. That's the 1231. That was done before or essentially maybe contemporaneous to the filing. It did not include a summons. It also did not include essentially notice of the proper notice of seeking of the temporary order. But in any event, the actual service of the restraining order has never been done to the resident agent, as I understand it.
It's been served on the entity itself, though, the restaurant proper, which is what the DBA is of the entity.
It's an LLC, counsel. Very clear, an LLC is served the resident agent. This was the issue that came up the very first hearing we had. And again, the summons issue is a secondary issue that came up as I was trying to prepare for today's hearing, and I was looking back to see whether we had jurisdiction over the defendant.
Well, the address for the registered agent is the same as the address for the restaurant. So we left it with a person of suitable age and discretion at the address of the registered agent.
Counsel, that only works if it's a residence. You know that. It doesn't work for a business address. So my real question here is, with a lack of a summons, how do we have personal jurisdiction in this case over the LLC? That's a very simple question, and I haven't heard an answer to that.
Well, our understanding, Your Honor, is that the WSHA statute confers that jurisdiction.
Over the defendant.
Correct.
Where does it say that? I mean, I've got that statute in front of me. It says the court has jurisdiction over the proceeding, pretty clearly, like any case that's filed. And I think the court can grant injunctive relief. That has no effect until it's properly served, though.
We will prepare a summons immediately and serve it on them if that's what is required, and it sounds as though it is.
Well, I believe that's just, I mean, that's what the court rules say. That's what the statute would say. In a civil proceeding, you serve an LLC by filing a petition or a complaint, and you serve that and you serve the summons on the resident agent. That's how you acquire jurisdiction over the defendant. And if you go to the court rules, and I look down through those, and if a statute provides for an alternative document, such as a notice in lieu of summons, that would be fine, but that's not what is provided for in the statute. The statute says file a petition like many other statutes do, which requires a summons. So, I mean, I think that's where I think the court clearly has jurisdiction to issue an injunctive order under the statute, but I don't think it has any impact until the court has proper jurisdiction over whoever it is that orders against. That's the concern I have. And I walked back through this because there was some concern I had. Okay, well, we had a governor show up at that first hearing, and they filed some documents. Obviously, that person was unable to represent the LLC. That was raised by Mr. Dew, and I can completely agree with that. By the same reasoning, that person could not waive the jurisdictional issue because they couldn't represent the corporate or the LLC. And when Mr. Chelsky entered his notice of appearance, he reserved those arguments. So really, I mean, at this point, I don't believe I have personal jurisdiction over the LLC because there's not been a summons served. And I think that's where I'm at. I have read through all of the rest of the documents, and I don't know if we want to go ahead and get that resolved first and then proceed. That may be a better way to go. But I'll leave that up to counsel.
If the court believes there isn't jurisdiction here, I'm not sure how helpful it would be to argue about the motion to dismiss on constitutional grounds, the standards for preliminary injunction, and whether there's been contempt. I am prepared to argue about those things today, but from what you're saying, Your Honor, I think we should cure the jurisdictional issue before we get down into the substance of this.
Mr. Chelsky, what's your thought on that?
Thank you, Your Honor. And as you can tell from my notice of appearance and the documents we filed, jurisdiction's always been part of our question and our issue in this particular case. I think, and it's my client's understanding and belief that we should probably remedy the jurisdictional issue first and then argue the merits and the facts of the case thereafter. So I am in agreement with the state that I think we need to remedy the jurisdictional issues first before we argue this matter.
Okay. That would make sense to me to do that. Then we have a clean record to work with. As far as process-wise, do you want to, I mean, we could set another hearing today. I don't know how much time it's going to take to get those issues resolved, but or have you noted on, whichever your choice is?
I'd prefer to set a hearing in 2 weeks. All the briefing's been done. I expect we'll be able to serve a summons and complaint tomorrow.
So, Danielle, are you on there?
Yes, I'm here.
What are we looking at on the 18th-ish?
So we could come back the same time on the 18th, 1 o'clock.
Is there any, let me take a look at that real quick. I think if we're going to do, I would prefer we set that at the 2 o'clock time.
Okay, we can do 2 o'clock as well.
Does that work for both counsel?
Yes, Your Honor.
I apologize. That does not work for my office. We're actually in a mediation on a separate matter on that particular day. But I am available in the morning on that day if that helps.
Do we have, I know I would be available at that morning. Do we have courtroom availability or staffing availability on the morning that day, Danielle?
Let me just look here real quick.
And while you're looking, if we can start at 10 in the morning on the 18th, that works for us.
I do think that we could we could have a courtroom available for the morning.
Okay. So let's shoot for the 18th at 10 o'clock. Does that work for Mr. Chelsky as well?
Yes, Your Honor, that does work for us.
Okay. All right. One comment I'm going to make before we adjourn today, since you've got some things to work on. Counsel, I've reviewed through all the documents in this case. One thing I would strongly urge both parties to do would be to sit down and see if you can come to some sort of agreement on this case. I think everybody would probably be happier with that outcome were you to do that.
Very good, Your Honor. Thank you.
Yes.
All right.
Yes, Your Honor. Thank you.
Very good. We will see you all on the morning of the 18th.
Thank you very much.
Thank you, Your Honor.
You're welcome.